Is 9:01 a.m. on March 23rd, 2021. If I could have the attorneys for the parties please put their appearance on the record.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
All right. Good morning. Please tell me your name.
Dalton Buckley. Morning.
You're here in case number 21 CF 3359AO, charged with aggravated battery on a pregnant person. I'm going to appoint the Public Defender's Office to represent you. I reviewed the probable cause affidavit. There is probable cause in this case for your arrest. Your bond will be $5,000. You're not allowed to have any contact with the victim. Do you know what no contact means?
Yes.
You can't call her on the phone, send a message through friends or family, contact her through social media. No contact at all. You understand? You have to answer out loud. I'll further order that you're not allowed to have contact with any of the witnesses in the case. You're not allowed to possess a weapon of any kind, a firearm or ammunition. Were you two living together? You're not at this time. I'll order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot contact her to set up that time. Do you understand? Are there any other conditions the state would request?
Your Honor, I believe there's a victim that just arrived.
I'm sorry, I can't hear you.
I believe there's a victim that just arrived.
All right. Ma'am, do you wish to testify this morning?
No, I do not.
All right. So I just said, are you here on Carlton Buckley?
Yes, that's correct.
All right, so I just set his bond at $5,000. He's not allowed to have any contact with the victim. He's not allowed to return to the residence. And did the state say there are no other conditions they would request?
No, Your Honor.
All right, good luck, sir.
Let me sign this right.
Thank you, ma'am. Maintain separate, one-time return with law enforcement. Please tell me your name.
Leah Bell.
You're here in case number 21MM1987AO, charged with domestic battery. Ma'am, what's your name? You, what's your name?
Oh, Sheena Hudson.
Just a moment, let me get your case. You're here in case number 21MM1988AO, charged with domestic battery. There is probable cause in both of your cases. I reviewed the probable cause affidavits. I'll appoint the Public Defender's Office to represent each of you, knowing they'll have to conflict off one of the cases. At this time, both of you, your bond will be $500. You're not allowed to have contact with each other. Do you understand what no contact means?
Yes.
Yes.
You can't talk on the phone, you can't send a message through friends or family, you can't talk on social media, no contact at all. Neither of you is allowed to possess a weapon of any kind, firearm or ammunition. Were you living together?
Yes.
At this time, I'll order you maintain a separate residence. That means you can't live together. You understand?
Yes.
Yes.
So for each of you, I'll allow a one-time return with law enforcement to gather belongings, but you have to maintain separate residences. You understand that?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
All right, good luck to both of you. Please tell me your name.
Romel Fernandez.
You're hearing case number 21MM1981AO, charged with battery domestic violence. I'll appoint the Public Defender's Office to represent you. I do find there's probable cause in this case. I'm going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You understand you can't send a message through a friend or family or call them on the phone, no contact at all.
Understand?
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Is this your residence?
Yes.
Does he live there?
Yes, he rents from me, yes.
I'm sorry, I couldn't understand. I couldn't understand that. Can you tell me that one more time? You said
I
yes.
rent, and I let him move in, I let him rent out a room.
Sign here.
So at this time, I'm going to order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. So what that means is if he's living there, you can't live there. You understand?
I understand. I just don't know where I'm gonna go.
You'll have to come up with a place, but I'll allow you to return one time with law enforcement to gather your belongings. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Good morning, please tell me your name.
Lakaya Man.
You're here in case number 21MM174AW, charged with battery, domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't talk on the phone, send a message through friends or family, talk on social media, nothing. You understand?
Yes, ma'am.
I'll order you're not allowed to possess a weapon of any kind, firearm, or ammunition. Were you two living together?
No, ma'am.
All right, I'll order that you maintain a separate residence. Who was living at this location, 649 Bethune Avenue?
Him and his grandmother.
All right, so that's his house, not yours?
That's his grandma. Yeah, he's residing with his grandma.
All right, then I'll order that you're not allowed to return there. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. Please tell me your name.
Joseph Villanueva.
You're here in case 21MM1995AO, charged with battery, dating violence. I'll appoint the public defender's office to represent you. Did you wish to be heard, Ms. George?
Yes, Your Honor. As to PC on the dating violence, I see a domestic violence. I don't see the battery dating violence. In order to have dating violence, you have to have individuals with, it has to state that there's a significant relationship of romantic or intimate nature, that it existed for more than 6 months, and the characterization of that relationship must be sexual involvement between the parties. And here, they state that they're married and that they began to live together in November, which would make this a domestic violence dispute as their spouses, but not a dating violence dispute. So if you look at the statute, 784.046, battery dating violence, you must meet specific criteria. In the arrest affidavit, it literally says that they are married. They've been married for 1 year and reside as a family together. However, in order to have dating violence, in the arrest affidavit, there must be something stating it's affectionate in nature, it's sexual in nature, and here we have none of that. However, if you look at the domestic violence statute, that says family or household member means spouse, former spouse, related by blood, marriage. Domestic violence means any assault, aggravated assault, battery, sexual assault. Here we have a domestic dispute in a marriage as opposed to a dating violence dispute.
So you're asking the court to find probable cause for battery domestic violence instead of battery dating violence?
Yes, Your Honor.
What says the state?
Your Honor, the definition of dating violence is a continuous or significant relationship of a romantic or intimate nature, and the existence of the relationship shall be determined based on the consideration of one of the following. that the relationship existed more than 6 months, affection or sexual involvement between the parties, frequency and type of interaction between the persons involved in the relationship must have included the type of persons have been involved over time on a continuous basis during the course of the relationship. I would argue that this relationship meets all 3 of those requirements. They have been dating for at least 6 months, as they've been married for at least a year. And it says the two have been dating for some time and lived together as a couple. Since they are married, it is likely that there has been a sexual relationship between the two, and they have been involved over a time on a continuous basis. The state would argue that there is a dating violence. There is PC for dating violence here. However, if the court wants to do domestic violence, they understand.
What's the statute that you're quoting, Ms. George? 784.046?
.046, or date and violence, Your Honor.
Yeah, it's the definition of dating violence.
Not amenable, given his lengthy prior history, to include firearms as a juvenile. Hopefully folks get it when they're in the juvenile system.
I think it's sub D.
Stop their conduct. Some folks don't. And those folks are a danger to society that don't get it. So I would not be entertaining a youthful offender sentence on this young man.
So I'm reading the statute and the probable cause affidavit. Ryan advised the two have been married for approximately 1 year, reside together as a family. However, Villanueva advised the two have only dated for some time, but have lived together as a couple since November. So both parties stated that they lived together as a couple. So a dating relationship must have existed within the past 6 months, so November, December, January, February, March. 5, well, your client said, have dated for some time, but lived together since November. So they were dating before November, right? So that's within the past 6 months.
Yes,
The
Your Honor.
nature of the relationship must have been characterized by the expectation of affection or sexual involvement between the parties. Dated, lived together as a couple.
That's all it says.
So you don't think that's sufficient to establish there's an expectation of affection or sexual involvement between the parties? If they said they lived together as a couple?
No, if you're looking at the 4 corners of the affidavit, we don't have that in there. My argument is that dating violence, this statute is not meant for this particular situation. I believe this is a domestic violence situation in which they are living together. However, they stated they are married.
I have to send his prints for comparison. So
I suggest that you go ahead and do it then, Mr. Schrager, if that's something that you.
And then the third is the frequency and type of interaction between the persons involved in the relationship must have included that the persons have been involved over time and on a continuous basis during the course of the relationship.
How about you give him a little bit of time so he can discuss it with his family? Give him a cutoff.
So the defense's argument is, unless the words expectation of affection and sexual involvement are included in the affidavit, there is no probable cause for dating violence?
There is nothing in this affidavit that says they're sexually active or there's affection or anything, Your Honor.
Married, lived together as a couple, you don't think that's sufficient to establish probable cause?
No, Your Honor, it hasn't been sufficient before. Today,
When
on numerous cases before this court, Your Honor.
this court has not found probable cause for dating violence?
When the situations are of such nature, yeah.
This court
Yes.
has found no
Well,
probable
not
cause?
you in particular, Your Honor.
I don't recall ever doing that. I'm not saying it hasn't happened, but I can't.
I take that. If I take back my argument, Your Honor. For dating violence.
The offense of battery occurs when a person actually intentionally touches or strikes another person against the will and intentionally causes bodily harm.
I understand what you're saying. I take back my argument.
All right, sir, do you wish to testify this morning?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yeah.
Please state your name for the record and spell your last name.
Cody Ryan, R-Y-A-N.
State you may inquire.
Good morning. Can you please state your relationship to the defendant?
Mr. Villanueva is my boyfriend.
And how long has he been your boyfriend?
5 months.
Are you afraid of him?
No.
Would you be afraid of him if he was released from custody today?
No, I would not.
Has anything like this ever happened before?
No.
Are you willing to call 911 if anything like this were to ever occur in the future?
Yes.
Were drugs or alcohol involved in this incident?
The incident that is in the report?
Yes.
Yes.
And do you want to have contact with the defendant?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Why doesn't he qualify for pretrial release? Oh, he refused to talk? Oh, all right. At this time, your bond is $500. Based on the testimony here today, I'll allow you two to have peaceful contact. Do you understand what peaceful contact is?
Yes.
You can't even raise your voice. Also, I am finding that there is probable cause for battery dating violence. You're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. I want to be sure I understand your testimony here today, sir. You do want to continue living together?
Yes.
All right, I'm going to allow you to return to the residence, but only having peaceful contact. Do you understand?
Yes.
And you understand this court doesn't have jurisdiction over him, only over you. So if there's another incident, you're the one who comes back to jail. You understand that? Okay. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Thank you for coming, sir.
Thank you.
Please tell me your name.
Rose Casting.
In case 20 CT 6492, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of operating a motor vehicle without a valid driver's license. There is no bond authorized on that capias. I'll appoint the Public Defender's Office to represent you. In 21 CT 1689, you're here because a capias was issued for your arrest for failing to appear for arraignment on another charge of operating a motor vehicle without a valid driver's license. That capias authorizes you to be released on your own recognizance. I'll appoint the Public Defender's Office to represent you in both.
We have two.
I only have
I
one.
only have one, Your Honor.
I'm sorry? Right, 1689 is the ROR, and 20 CT 6492 is the no bond. Oh,
We have the 6492. I don't have the other.
they're not done. That's why I didn't give it to you.
The state is offering a withhold of education credit time served. Is that the one that she has 0?
On the 6492, yes.
She wants to accept the state's offer.
In one of the cases,
Yes,
and not the other?
the one she has 0 bond on?
Yeah, the 6492 case.
Yes.
And what's the reason the state's offering a withhold?
Your Honor, the other case, I didn't have it before the court today. However, she picked up that one after this one. Therefore, I didn't think it appropriate to offer an adjudication on her first no valid.
So then I guess the answer to my question is she has no criminal history?
No, Your Honor.
All right. Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
You had a moment to speak with your attorney about this. Did she explain to you the rights you're giving up by entering a plea today?
Yes.
You understand those rights?
Yes.
Do you have any questions for me about them?
She said the no contest one?
Entering a plea of no contest.
Yes.
Get closer to the microphone. What's your question?
Nah, I'm kind of lost. I'm going to trial?
No. If you enter a plea of no contest today, there will be no trial on this. I'll sentence you today.
Okay.
Is that what you want?
Yes.
You understand there will not be a trial. You're giving up your right to remain silent. You're giving up your right to present any defenses you have. If you enter a plea today, I'll sentence you today.
Yes.
That's what you want?
Yes.
You understand if you're on probation, this plea could violate that probation?
If I what?
If you're on probation, this plea could violate your probation.
I'm not on probation.
I believe you, but I have to advise you of that. You understand if you're not a United States citizen, this plea could subject you to deportation?
No.
I'm sorry? I can't hear you.
No.
All right, if you're not a United States citizen and you enter a plea today, you could be subjected to deportation. Do you understand that?
Yes. So I'm a plead no contest.
I can't hear you.
I'm a plead no contest.
All right, but you understand that if you're not a United States citizen, entering a plea of no contest can get you deported.
Oh, so what can I do not to get deported?
I can't hear you.
What can I do not to get deported?
So if you enter a plea of not guilty, we can set this for a trial at a later date. That won't get you deported today, but it doesn't resolve the case. So anytime you enter a plea or are found guilty of a criminal charge, you can be subject to deportation. So do you want to talk to your attorney about this some more? Did you say yes?
Yes.
All right, Counselor. Do you want to enter pleas of not guilty?
Instead of entering a plea, maybe you have certain constitutional rights that are clearly set forth in the plea form that you read. When you enter a plea, you give up those rights. Do you understand that? And is that what you want to do, ma'am? Or is there stipulations to a factual basis? Ma'am, I previously read the affidavit.
Your Honor, my client understands the consequences of accepting the state's offer. However, she wants to accept the withhold credit time, sir.
All right, so you understand that you could be deported for this if you're not a United States citizen,
Yes.
and you still want to enter this plea? Has anyone threatened you or promised you anything to get you to enter this plea? At this time, how do you wish to plead to the charge of operating a motor vehicle without a valid driver's license?
No contest.
I'll accept your plea of no contest in case number 20 CT 6492. I'll withhold adjudication, give you credit for 3 days in jail. I have to order that you pay court costs. I'll give you a year to pay them. Do you understand? You have 30 days to appeal in writing. Good luck.
So what do I do?
I can't hear you.
What do I do?
I'm sorry?
You gave me a year for what?
To pay your court costs.
Okay.
It's $306, I think, or it's around $300.
You said 3 days in jail?
Yes, I gave you credit for the 3 days you've spent in jail.
Okay, thank you.
Good luck. Please tell me your name.
Rosalind Rodriguez Barrios.
In case number 21CT2210, you're here charged with driving while license suspended. There is probable cause. I'll appoint the Public Defender's Office to represent you. Your bond is $500. You can't drive without a valid driver's license. As to case number 20CT5058AO, I show that you're out on bond in a driving while license suspended charge. I'm going to revoke your bond at this time.
The state is offering an adjudication of guilt credit time served on her new moving traffic violation. So we would ask that you take no action if she resolves her case today.
Perform 100 hours of alternative community service work to be done at the rate of no less than 8 hours every 30 days. I'll give you 60 days within which to perform the first 8 hours. You'll pay restitution in the agreed upon sum of $320, cost of transportation to the Orange County Sheriff's Department in the sum of $1,970. And there are some court costs and cost of prosecution that Madam Clerk will now announce. I'll also reserve jurisdiction.
Does the state show the reasons her license is suspended?
The reasons that I saw were mostly failures to pay. Therefore, I did not believe that this could be upgraded to a HTO or a 2 prior, which is the reason for the offer.
I can't hear the last thing you said.
I don't believe it can be upgraded to an HTO or a 2 prior, which is the reason for giving the offer. I see most of our suspensions are financial in nature.
It's not, it has nothing to do with drugs.
Now, with the restitution and the cost of transportation, that
What I saw, no, Your Honor.
$958. I can put you on a monthly payment plan that you can afford once you're released, and I'll give you 90 days. That's 3 months to start making the first payment. What is the most that you can afford to pay, ma'am?
All right, I'll consider not revoking it.
$100 a month with the first payment to review again within the first 90 days of today. All payments will go first towards restitution.
I'll consider if she enters a plea today.
And then towards court costs. Ma'am, again, I'm going to impress upon you that you must report to probation within 24 business hours of your release, and you must follow their directions with regard.
She's going to accept the state's offer of an adjudication of guilt credit time served.
Raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
For probation, are you there at BRC?
Hold on one moment.
All right, thank you for that, I appreciate that.
I have a note that says she has a failure to appear in the open case and that a capias just hasn't been issued yet.
If you could not afford an attorney, one will be appointed to represent you. Good luck to you. And if I can approach with a change of address form, if you can give that to Madam Clerk.
Ma'am, your attorney advised the court that you want to enter a plea today. Is that true?
Yes, ma'am.
You understand the rights you're giving up by entering this plea?
Yes, ma'am.
You understand if you're on probation, this plea could violate that probation? You understand if you're not a United States citizen, this plea could subject you to deportation? Do you have any questions for me about the rights you're giving up?
No, ma'am.
Has anyone threatened you or promised you anything to get you to enter this plea today?
No.
All right, at this time, how do you wish to plead to the charge of driving while license suspended in case number 21CT2210?
No contest. I'm sorry. No contest.
All right, I'll accept your plea of no contest. I find it's freely and voluntarily made. Ma'am, why were you driving?
Oh, I wanted to go see my auntie. I was just being stupid. I knew already, and I can't drive, but I raised my right hand again. I promise I'm not gonna get in a vehicle no more.
Because you know that if you keep doing that,
It's gonna be.
eventually the state can charge it as a felony.
Yes,
And
and
I heard what the state said about this one. She doesn't think this will count toward that enhancement.
I don't
But at
know.
some point, it's a felony.
I don't want no felonies in my record.
You
I
understand?
already got too many things going on.
All right, I'll withhold, you said a withhold or an adjudication?
Adjudication, Your Honor.
All right, I'll adjudicate you guilty, give you credit for, how many? 1 day in jail. I'll have to order that you pay court costs. I'll give you a year to pay them. At this time, I'll take no action and you're out on bond case. Good luck, ma'am.
Thank you. Can I ask?
Please tell me your name.
Trishante Walker.
This is case number 21CT 1140. A capias was issued for your arrest for failing to appear for arraignment on a charge of driving while license suspended. Your bond is $1,000. I'll appoint the public defender's office to represent you.
Your Honor, just so the court knows, the offers conveyed in this case, for the 21CT 1140 that happened first in time, state offered to withhold a credit time served. As to the newer case, it was an adjudication credit time served, as she has no prior history.
Thank you. All right, ma'am, you have another case. Your other case is 21CT 2211AO. You're here charged with driving while license suspended or revoked with knowledge. There is probable cause in that case as well, and I'll appoint the public defender's office to represent you.
Your Honor, we're not going to accept the state's offer.
All right, your bond is $500. You can't drive without a valid license. You understand that?
I understand that.
I need you to get closer to the microphone.
I understand that.
All right, so your bond in the FTA case is $1,000. In the new case, it's $500. Good luck, ma'am.
You want to place say it's medical?
21CT 1735. He's here for an arraignment on a driving while license suspended. I'm going to appoint your office, Ms. George.
We'll waive, Your Honor.
Thank you.
Division 85, pretrial conference will be April 12th, 9 a.m., courtroom 4A.
Please tell me your name.
Derek Dent.
21MM57AE. You're here charged with trespass and conveyance, and you're represented by the Office of the Public Defender.
We're going to enter a plea of not guilty.
Division 82, pretrial conference date will be April 19th, 10:30 a.m., courtroom 10B.
Good luck, sir.
I wanted to ask about my bail. I had my bond revoked.
That may be true. I don't know the answer to that.
You know if anybody can help me get my bond back?
Yes, your attorney can file a motion in front of the trial judge to get your bond reinstated.
Here you go.
James McNeil, medical.
21MM58. He's represented by your office counselor.
We'll waive and enter a plea of not guilty.
Division 83, pretrial conference date will be May 12th, 1 p.m., courtroom 6C.
And I don't know what the status hearing is on Nicholas Fank. I don't know what those things mean. Oh, thank you. I'm just going to start saying random letters to you, Dexter. All right, is the state ready for 33-day motions?
Yes, Your Honor.
I have Brown Jr., 21 CF 1870.
Notice of non-filing.
Hawkins, 21 CF 1824.
Notice of non-filing.
Hawkins, 21 CF 446.
No information.
Johnson Jr., 21 CF 1814.
1814, notice of non-filing.
Leon, 21 CF 1871.
Notice of non-filing.
Neesmith Jr., 21 CF 1486.
Notice of non-filing.
Asenet, 21 CF 374.
Notice of non-filing.
Tyler Payne, 21 CF 1618.
Filed yesterday, Your Honor.
Brittany Campbell, 21 CF 2055.
Filed yesterday.
Carlos Johnson, 21 CF 1183.
Filed yesterday.
All right, is there any other business before court is in recess this morning?
No, Your Honor.
All right, have a nice day, everyone.
Well, Super Bowl, and I get about 3 or 4 other games a year.
Sorry to hear that.
You say sorry to hear that.
Yeah.
That's like death sentence.
Yeah. What it is. A lot of nursery rhymes and little kid shows. That's what happens at my house. I go to bed early, so I don't catch none of the games.
You don't know.
Hmm?
Is that here you don't know?
Let me see that. Yeah. Judge Gibson's just here. Yeah, it seemed like y'all were on.
Oh, we won?
And
You have a problem?
just told me. Huh?
You have a problem this morning.
I don't know.
It was loud and clear.
Oh, this is George. Or can you guys test your mics out there?
You see it? You see anything?
I'm trying to figure out what he charged it as. I'm trying to figure that out, but I do see the Oxy being 7,
Okay. Yeah, I was confused. I was like, I don't know what it.
and then 7 to 14, then 14 to 25, 25 to 100.
Right.
Is a lot. I'm trying to figure out what I'm assuming Daniel, yeah.
Lose interpreters, I was gonna lose him. That's right.
Let's see if I'm just missing something, and I reread it to make sure there was nothing else.
Yeah, that's what I reread
But
it
they
like 3.
didn't weigh the cannabis.
'Cause
All
that,
it- all it was the Oxy and the cannabis.
Cause that, yeah, the cannabis wasn't tested or weighed or something.
Yeah. You feel attempted to field test it. It was unsuccessful. You didn't obtain a weight. So thank you. That's great.
Yes, sir.
I'm open court reporting, and I'm hearing everything that's going on. It seems like just that one microphone that's there,
No.
the little circular one,
Yeah, but
is giving you a problem at this point.
the microphone's out there, and I tried to call when I got interpreting on the line. I couldn't hear them either.
You couldn't hear interpreting.
Yes, let me try to call them back and see if I can get them. So I don't hear it ringing, like the speakers aren't working either. So that's what I mean. Maybe the mics are on, just the speakers aren't working.
Good morning. This is Dalia Romero, Spanish interpreter on the line. How are you?
Hello, hello. You guys hear me interpreting?
Yes, I can hear you. Can you hear
Yeah,
me?
see, I can hear you, but you can't hear me.
I can hear you.
Yep.
I
Can you
can
see
hear you.
the headsets are working? Can you see if you can try to connect to the headsets? Because if I don't hear my voice, I'm fine with that. Can you? No connection to the headsets.
No, he cannot. That's interesting.
Okay, let me review your system then, sir.
Yep, that sounds like a workable plan there. All right, we'll try to call you guys back in a minute.
Thank you.
I was talking to interpreting. So let's go for the go reboot fix.
All right,
All right. All right. Thank you.
Yeah. They'll put it on you. Yeah. How you did like this? I say she is off the chain. Going to force it. It's pleasant and it's like soft. Yeah.
Four grams number, but it's for drugs that aren't these drugs. Hello?
There we go. All right, we're live now. Do it. There it is. Thank you. Thank you. Have a good one.
Good morning. This is Dalia Romero, Spanish interpreter again on the line.
There we go. Good morning, Mr. Romero. This is Judge Bain calling from the BRC. We have a couple people that need your assistance this morning.
Okay, one moment, Your Honor. Allow me to connect to the podium, please.
There we go. All right, the first case I have is 2021 MM 1997 AO. Actually, no, who's this? What happened to?
Valentin.
Pedro Froilan Aguilar
Valentin
Sanchez.
bonded.
Yes, bonded, okay. All right. This is
Froilan Aguilar Sanchez.
Aguilar Sanchez? All right.
Aguilar Sanchez, yes, sir.
All right, sir, you are here in case 2019 CT 4643AO for a charge of violation of probation. The judge signed your warrant, set your bond at $0. Your bond remained at $0. I want to appoint the public defender to represent you in this case. Ms. George, do you want to waive his VOP arraignment and set him for a status?
Yes, Your Honor, we'll waive.
We're entering a denial?
We'll enter a denial, sir.
BOP status will be April 21st at 9 a.m., courtroom 9C.
All right, sir, have a great day. All right. Good morning, sir. Can you tell me your name?
Jonathan Perez Muñiz.
Jonathan Perez Muñiz.
Mr. Moniz, you're here in 2021 CF 3361AO on 3 charges: possession of fentanyl, resisting officer without violence, and possession of drug paraphernalia. I did review the charging affidavit in this case, and I did find probable cause for your arrest. I'm going to release you on recognizance at this time with these conditions: that you not possess any drugs or alcohol by a valid prescription, that you not return to the scene where this incident happened. If you're able to, and then you're able to keep up with your court dates, I'm going to appoint a public defender to represent you in this case. If you're able to do that and stay out of trouble, you'll stay out on your own release. If not, then you're going to be staying here with me at the Orange County Jail. Have a great day, sir.
Eso hoy. Eso es hoy.
Is that for today?
Yes, that means you can be released today. Can't possess any drugs or alcohol.
Okay.
Can't go back to where this incident happened. You have to show up at your court dates and keep in contact with your attorney, which is the public defender's office. Be able to do those things. Then you stay out on release. If not, then you'll be staying here with me at the jail.
Entendido.
Have a great day.
I understand.
Oh, sorry. That's too fast. Good morning, ma'am. Can you tell me your name?
Victoria Sandoval.
Victoria Sandoval.
Ma'am, you are here in 2021 CF 3366AO on a charge of grand theft. The court did review the charging affidavit in this case, and I did find probable cause for your arrest. I want to stay your bond in this case in the amount of $2,000. Conditioning your bond, not return to the scene of this location. You do not have any contact with any victims, witnesses, or co-defendants in this case. All right. And ma'am, you're going back to, is this New York?
Yes.
All right.
Yes.
All right. So stay out of trouble, because there's a long bus ride is in front of you if you get in trouble in New York, and Florida extradites you back here, okay? We'll appoint a public defender to represent you. Have a great day, ma'am.
Oh, ok, gracias. Yo quisiera
Okay,
saber
thank you.
si, pues yo no tengo la fianza completa, entonces no hay una posibilidad de que me ayudes a bajar la fianza porque yo tengo que regresar a Nueva York a trabajar y si me dan una fecha para volver, igual yo puedo volver.
Is there any way that I don't have all of the money for the bond? Is there any way the bond can be reduced? I do have to go back to New York to work, and for the next court date, I can come back.
All right. Well, based on your history, based on the fact that you have no connections here in the state of Florida, I'm not willing to reduce your bond. You can work with a bondsman, and if it becomes a problem later on, you can speak to the division judge about a reduction in your bond, okay? But you have an attorney from the public defender's office, which is that green sheet of paper in front of you. If you have any questions, call the phone number on that paper.
Thank you.
Thank you.
All right, good morning, sir. Can you tell me your name?
Mateo Celis Ruiz.
Mr. Silas Ruiz, you're here in 2021 CF 3368AO on a charge of grand theft. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to stay your bond in this case in the amount of $2,000, condition your bond and not return to the scene of this location, not have any contact with any victims, witnesses, or co-defendants in this case. I'm going to appoint the public defender to represent you. So they're going to but they're going to probably withdraw. You're going to get somebody called regional conflict counsel because they can't represent you and the lady that was in front of you before this incident, like in front of you, because both of you are co-defendants in this case. You're also from New York, so please do not violate my orders to get in trouble, because there's a long bus ride ahead of you if you do that. Have a great day, sir.
I want to know if that, quiero saber si hay posibilidad de reducir un poco la fianza. Es que no tengo todo el dinero.
I would like to know if there's a possibility of a bond reduction because I do not have enough money.
All right. Well, not based on your history as well, based on the fact that you have no connections here in Florida or the Central, and more importantly, the Central Florida area, the court is not inclined to reduce your bond at this time. You can call the number on the piece of paper in front of you. They can direct you either to their attorneys or regional conflict counsel. And if you need to get a bond motion filed in front of the cert division judge and to reduce your bond further, but not at this time. You can work with a bondsman, they get the bond posted, but have a great day, sir. All right. Thank you, Madam Interpreter.
You're welcome, Your Honor. Have a good afternoon.
You too.
Thanks.
Come on, sir. Can you tell me your name?
Sean Cronin.
All right. Mr. Carrin, you're here in 2021 CF 3337AO on charges of, you're arrested on a warrant for possession of fentanyl. I don't have any history for him. Yeah, but is he in on a zero bond on the failure to appear? Because I need.
$3,000.
All right. All right, sir, I'm going to stay your bond in this case amount of $1,000, condition your bond not possessing any drugs or alcohol without a valid prescription. All right. Appoint a public defender to represent you in your case. Have a great day. All right, good morning, sir. Can you tell me your name?
Matthew Kabasa.
Mr. Cabasso, you're here in 2021 CF 3336AO on a charge of burglary of a structure. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I want to stay your bond in this case in the amount of $3,500, condition your bond that you do not return to the scene of this location, don't have any contact with any victims or witnesses in this case. All right, have a great day, sir. Well, you're going to appoint a public defender to represent you while you're here. Have a great day.
Wait, so what did happen?
Your bond will stay at $3,500. I appointed the public defender to represent you in this case. You cannot return to the scene of this location, can't have any contact with any victims or witnesses.
Am I getting released today?
If you're able to post bond, yes.
Okay. Can I just get it taken care of today and we ask for something like?
Not with felony charges, sir. Only misdemeanor.
I have a felony charge?
Yes, sir. Burglary of a structure is a felony in the state of Florida. It's a third-degree felony, punishable up to 3 years and 5 years in the Department of Corrections. $5,000 fine.
Charge was trespassing, I thought.
No, sir. Burglary of a structure.
I didn't even know.
I don't want to discuss, I don't want to have this conversation with you because everything you talk to me about is on the record. So what you maybe think is innocuous and not something that's going to get you in trouble, probably is going to, maybe most likely going to get you convicted of this charge.
Dalton, is mental health.
Okay. This is 2021 MM 1991AO, Donald Ayers. One point, the public defender represent him.
Will waive, Your Honor.
All right, so I'm going to have Mr. Ayers screened for mental health pretrial release. If he does not qualify for mental health pretrial release, I'm going to set his bond amount of $250. Condition that he did not return to the scene of his location, not have any contact with any victims or witnesses, not going to take any action on his 2021 MM 1159 AO case. So mental health PTR screening first. If he does not qualify, then bond. All right. Morning, sir. Can you tell me your name?
Ronald D. Guffey.
Sir, you're here in 2021 MM 1993 AO on charge of trespass after warning. I did review the charging affidavit in this case. I did find probable cause for your arrest. Can you make an offer in this case?
Yes, Your Honor. An adjudication, credit time served, and no return to Hollywood Plaza, located at 8050 International Drive.
All right. Mr. Gallery, do you have an address where you get mail?
Not right now, sir. I've been working with, I only make $60 a day. I work for staff zone.
Yeah.
So right now, I don't have nothing.
All right, sir. I'm willing to accept this offer from the state of Florida, but however, I'm going to change some of the conditions as to your release cases. Because your felony cases, your judges have been looking for you. You missed arraignment. They've reset your arraignment because they can't keep in contact with you.
Yeah, well, they stole my phone.
I'm telling you, I'm just letting you know what's going on. So eventually, a judge is going to issue a warrant for your arrest because they can't get you into court.
I didn't know that happened.
I'm telling you about this so you won't get in trouble later on.
Okay.
So I'm going to try to change some of your conditions. So you got to go by the public defender's office and check in. So you can't just like roam around, there's all these cases out here, and we're not going to worry about it and wait till something happens. So part of your conditions in your other case, going to change them, is you have to go to the public defender's office like at least twice a month to check in so you can get your court dates, make sure you don't miss any more court dates. All right. Sir, do you want to accept that offer from the state of Florida? Yes. Adjudication of guilt, credit time served? All right, can you raise your right hand and be sworn in? You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God. Yes, sir. All right, put your hand down. Sir, you're here in 2021 MM 1993 AO on charges of trespass on property after warning. That is a first-degree misdemeanor. It's punishable to 1 year in the county jail and a $1,000 fine. Do you understand that? Do you want to enter a plea of guilty or no contest to resolve this case?
No contest, sir.
Do you understand entering a plea of no contest, you give up certain constitutional rights?
Yes, sir.
You understand that one of those rights you give up the right to have a trial where the state had to prove your guilt beyond reasonable doubt. Where's this plea form? Did we not get the plea forms? Did we not get plea forms yet?
I haven't been given any plea forms.
All right, so I got it. Joe, I thought we had ordered something from the courthouse. But, okay, I guess I'll talk to Mr. Erling, I guess, after we're done here. I thought that had happened. All right, so do you understand that you waived up your right to have the attorney appointed to represent you in this case?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication? Have you now or in the past been diagnosed with a mental health illness?
Yeah.
What is that mental health illness?
I got bipolar, I guess is what they.
All right. Do you take any medications for that mental health illness?
Yes, I take them.
All right. Are you suffering from any of the symptoms of your mental health illness right now? All right, are you under the influence of any drugs, alcohol, or medication? Has anybody forced, threatened, or coerced you to enter this plea? You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation. All right, sir, I did review the charging affidavit. In this case, I did find a factual basis for the entering of your plea. I'll accept your plea of no contest, find that your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. All right, sir, when this incident happened, you were out on release or bond in 2021 CF 1578AO and 2021 CF 1852AO. I'm going to modify those conditions to include this. You have to report twice a month to the public defender's office on Orange, and that's at the courthouse.
Yes, sir.
So you gotta go by there twice a month to make sure you don't miss any court dates. All right?
Yes, sir.
I suggest you go there now, because I think you have an upcoming court date based on the court file I saw pretty soon. So you need to make sure you make those court dates. Otherwise, I think Judge Roach is one of your judges, and I think Judge Calderon is your other judge. You're gonna start issuing warrants for your arrest.
I don't want that.
All right?
I do not want that.
Have a great day. No, not taking any action, no other than that.
Manual bond.
All right. Hey, tell me your name.
Christina Moore.
Ms. Moore, you're here in 2021 MM 1989AO on a charge of petty theft. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. Is there an offer for Ms. Moore this morning?
Yes, Your Honor, it's a withhold credit time served and no return to Walmart. I do believe she may qualify for PTD.
There's an open case.
She might.
With an open felony case?
If that one goes to drug diversion, which I believe it is, then she would. But that's why I conveyed an offer anyway, just in case she did want to resolve it today.
Did you see something in her court file that said, well, on your side maybe?
I saw notes from the ASA that it was a consideration.
All right, Ms. Moore, I am not likely to accept that offer from the state of Florida without revoking your bond or your pretrial release on your other case. So it's up to you whether you want to get that case over with or not.
I'm sorry, I'm a little confused. I know.
You have a felony case open in 2019 CF 14065 AO. My review of that court file is that just like about last week, the judge released you on pretrial release.
Yes, sir, he did.
And you're in front of me for a new case,
Yes, sir, I am.
which gives me less likely, and then previously in that same case in 2019, you failed to appear several times, and other things going on with warrants have been issued for your arrest. So I'm unlikely to not take action on revoking that bond in that case, that pretrial release in that case, even if you do resolve your case today. So it's up to you whether you want to do that or not. You have appointed public defender represents you, so Ms. George can talk to you about that, but it's up to you.
Your Honor, just a quick question. I know you were gonna revoke. Are you planning on setting it at 9?
I am at this time, based on the history in that case.
Yeah.
Your Honor, if my client accepts the offer, would you be inclined to at least set a monetary bond on the arm bond?
Not without talking to the circuit judge first.
Okay. Okay, Your Honor, we're gonna, not accept the state's offer.
All right, ma'am, I'm going to stay your bond in that case in the amount of, what is it, 250 or 500? $250. Issuing a bond not return to the scene of that location, not possessing any weapons or firearms, and to also not having contact with any victims or witnesses. As for 2019 CF 14065AO, the court is going to revoke that bond based on the probable cause determination 2021 MM 1989AO. Going to set a new bond in that amount case at $0. Appointed public defender already represent Ms. Moore in her new case. I think she did already represent her in her other case.
I believe it was a private attorney, Your Honor.
Private attorney?
Yes, Your Honor.
All right.
You see that?
In the 2021 case. 2019 case.
I see on the 19 case, according to our system, it still has the public defender.
Okay,
On
just wanted to make sure.
This new
All right.
case, it would still be the public defender, according to our system.
You said 250, Your Honor, on the petty?
Yes, sir. Yes, ma'am.
Just call them. Okay.
All right, have a great day, ma'am. All right, good morning, sir. Can you tell me your name?
Albert Smith, sir.
Mr. Smith, you're here in 2021 MM 1992AO on charge of trespass on a structure or conveyance. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. States an offer for Mr. Smith to consider this morning.
Yes, Your Honor, adjudication, credit time served, no return.
All right. Mr. Smith, you want to accept the state's offer of adjudication of guilt credit time, sir?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You put your hand down. Sir, you're here in 2021 MM 1992AO on charge of trespass in a structure or conveyance. That is a second-degree misdemeanor. It's punishable to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
You want to enter a plea of guilty or no contest to resolve your case today? You understand by entering a plea of no contest, you give up certain rights. One of those rights, you're giving up the right to have a trial where the state would have to prove your guilt beyond a reasonable doubt. Do you understand that?
Yes, sir.
You understand you're given the right to have an attorney appointed to represent you at a trial.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication? Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir. Yes, sir.
All right. All right, sir, I did review the charging affidavit in this case. I did find a factual basis for the entering of your plea. I accept your plea of no contest, find that your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs and cost of prosecution in this case of $273. I will order those costs be paid directly to the clerk within 1 year of today's date. You have 30 days from today's date to appeal your judgment, sentence, and writing. Have a great day, sir. Good morning, sir. Can you tell me your name?
Jamari Thomas.
All right, Mr. Thomas, you're here in 2021 MM 1996AO. You're arrested for 2 charges. One is trespass on property after warning and resisting an officer without violence. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. There's an offer for Mr. Thomas to consider this morning.
Not at this time, Your Honor.
All right. It was just like you guys can get in contact with somebody for PTR. Mr. Thomas, where are you going to be living if I release you on pretrial release?
14443 Yellow Butterfly Road.
Who lives there?
My girlfriend's family, because I don't have anywhere else to go.
How long you been living there with them?
Probably like over a year, 2 years.
How often do you work?
I was supposed to go to work today, but the cop wouldn't let me go.
All right, sir. I'm going to release you on pretrial release in this case. Condition your pretrial release and not return to the scene of this location. Not having any contact with any victims or witnesses. All right? You have to stay out of trouble. You have to stay out on release, all right?
All right, may I say something?
I want to talk to Ms. George because everything you tell me is on the record and can be used against you at a later date.
Thank you, Your Honor.
All right, have a great day, sir. All right, this is 2021 MM 1982AO. Mr. Amon, I'm going to point the public defender to represent him.
Will waive, Your Honor.
All right, there's already been a warrant finding probable cause for his arrest. As there's 2 charges. I'm going to say his bonds as set. I'm going to make a condition of his bonds that he not return to the scene of the location, have no contact with any victims or witnesses. Ms. George, we have English and Spanish for tomorrow. Free forms. No, just talking. Yeah. All right, sir, can you tell me your name?
Robert Bradley.
Mr. Bradley, you're here in 2021 CF 3364AO on a charge of possession of MDMA or ecstasy.
Yeah.
Court did review the charging affidavit. In this case, I did find probable cause for your arrest. I want to stay your bond in that case amount of $1,000. Condition of your bond and not possess any drugs or alcohol without valid prescription. You're out on bond in the Osceola County case 2021 MM 174AO. In that case, I'm going to revoke that bond. We're going to set a new bond in the amount of $5,000. Condition that bond not return to the scene of the location where the incident happened. No contact with any victims or witnesses. I want to appoint the public defender to represent you in all your cases. Have a great day, sir. Can you tell me your name, sir?
Richard Elijah Brinson.
Mr. Brinson, you're here in 2021 CF 3374AO on a charge of trafficking in cocaine in 28 grams or more. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to stay your bond amount of $50,000. Condition of your bond not possessing any drugs or alcohol without a valid prescription. I want to appoint the public defender to represent you in this case. And we already addressed the fugitive warrant that he's out on. Has already been addressed? We're gonna see. No, yeah, I'm asking to have we addressed that with him.
Stayed 50.
Okay. Okay. All right. Have a great day, sir. All right, Cruz bonded. All right. Good morning, sir. Can you tell me your name?
Leon Davis.
Actually, sorry, it's afternoon now. Good afternoon, sir. You're here, sir, you're here in 2021 CF 2665 AO on charge of burglary of a dwelling with a solid battery therein. The judge signing your warrant has already found probable cause for your arrest. State, what are you asking me to do to as to his bond conditions?
State is asking that you hold him no bond pending an Arthur hearing.
All right, I want to appoint the public defender to represent you in this case. Ms. George?
Your Honor, we reserve the right to have an Arthur hearing in the trial division. However, if this court is inclined to set a bond, we would ask that you set a reasonable bond, given the circumstances.
All right, since I don't have any victim input, I don't feel comfortable doing that right now. So the court's going to hold you at no bond until you get in front of the division judge in this case. Well, you want to talk to Ms. George? Have a moment, talk to Ms. George. All right.
My client is stating the victim is downstairs. However, Your Honor, I did state that she would have been brought up here if she was here.
Well, you had to have absolutely no contact with the victim in this case. Zero, none. Not from the jail, not from anywhere in the world. You understand that? You're not returned to the scene where this incident happened. You're not allowed to possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand that? All right. Have a great day. Can you tell me your name, sir?
Tyrion Griffin.
Mr. Griffin, you're here in two matters. The first one is 2021 CF 2950AO. On a charge of attempted first-degree murder with a firearm with a discharge and causing injury, home invasion, robbery with a firearm, aggravated battery with a firearm with a discharge, burglary of a dwelling with a solid battery therein, and grand theft of a dwelling of $100 or more. The judge signing your warrant has already found probable cause for your arrest. State, what are you asking me to do as to counts 1, 2, 3? Those are 1, 2, 4, and 4.
As to count 1, 2, and 4, given that they are life and PBL offenses, state would ask that you hold him no bond pending an Arthur hearing.
All right, Ms. George.
Reserve the right to have an Arthur hearing in the trial division, Your Honor.
All right, so as to counts 1, 2, and 4, the court's going to hold you at no bond as to those cases. As to count 3 in this case, going to set your bond amount of $50,000. Count 5, 1, 2, 3, 4. No, 50,000.
Oh, 50.
Yeah, 50,000. Count 5, we're going to set your bond amount of $1,000. Condition of your bond to have no contact with the victim in this case. Not allowed to possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. May not return to the scene of this location. May not have any contact with any co-defendants or witnesses in this case.
Yes, sir.
That includes the people that you may be in blood relation to.
Yes, sir.
Well, I'm going to talk to Ms. George first, but let me finish with the rest of your other cases got going on. So you're also here in 2021 CF 3364AO on a charge of possession of 20 grams or more cannabis. State, are you holding on to that one, or?
I'm taking no action at this time, Your Honor.
All right, sir, I want to stay your bond in that case. I think that's in front of me. In amount of $1,000. Condition your bond not allowed to possess any drugs or alcohol while about a prescription. You were out on bond in 2020 CF 15266AO when this incident happened. Of course, going to revoke that bond. We're going to set a new bond at $0. If you have any further questions, you can talk to Ms. George first and then ask me.
Just call this number. Thank you, Your Honor.
Thank you. All right, sir, can you tell me your name?
Lee Hughes.
Mr. Hughes, you're here in 2021 CF 3355AO on charges of armed burglary of conveyance with a firearm and aggravated assault with a firearm. Court reviewed the charging affidavit. In this case, I did find probable cause for your arrest. I want to appoint the public defender to represent you in this case.
Your Honor, I did have an argument on the armed burglary of a conveyance. Here, reading the arrest affidavit, it just states that he opened the door, but it doesn't state any part of his body entered that vehicle. When he stated he called 911, the victim, he backed away. So my argument is that there is no armed burglary of a conveyance with a firearm because there was no entry into the vehicle.
State.
Your Honor, he didn't make contact with the vehicle, as he did open the vehicle. And I believe that is enough for PC for the burglary of a conveyance, and with the firearm. However, if you are inclined to not find PC, state would ask for 24 hours.
All right. Based on the charging affidavit I have in front of me, that he did open the door, came in contact with the vehicle, and then pointed a weapon that could enter the vehicle. So he broke in with an intent to commit a felony therein, based on the charging affidavit I have in front of me. So the court's going to find probable cause as to count one. Say what you asked me to do as to count one, though.
The state's asking that you hold a no bond pending an Arthur hearing.
And Ms. George?
Your Honor, we would ask that given the circumstances that you set a reasonable bond. However, we do not want to waive our right to an Arthur hearing.
All right. So you're reserving to have an Arthur hearing?
No, we're asking that if you would take into consideration the facts of the case and set a bond. However, we do not wish to waive our right to have an Arthur hearing.
That's what I'm asking you. Are you asking me to reserve your rights to Arthur hearing and for me not to consider whether there's proof, evidence, presumption, great? I want to be clear because I don't want to mess this up.
No, I don't want you to find proof, evidence, presumption, great.
Okay. All right, based on the affidavit I have in front of me, the court's going to hold Mr. Hughes at zero bond in count one. Count two, going to set your bond amount of $5,000. Condition of your bond, you had to have no contact with the victim in this case. You are to not return to the scene of this location and not allowed to possess any weapons or firearms. The weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. And we can get you in front of your division judge to have a full Arthur hearing in this case with the victim and everyone there. I did appoint you public defender even though you didn't qualify. So I think you're going to be held here at the Orange County Jail based on the Florida Supreme Court order.
Your Honor, you said he didn't qualify. You're going to appoint us.
He didn't qualify, but he's going to be here. So the Florida Supreme Court told me I need to appoint him the public defender while he's here. He can always hire his own attorney later. All right, sir, can you tell me your name?
Chad Kilefner.
Sir, you're here in 2021 CF 3360AO on charges of possession of fentanyl. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. I'm going to stay your bond in that case amount of $1,000. Condition of your bond that you're not allowed to possess any drugs or alcohol without valid prescription. You be subject to random drug and alcohol testing at your expense. I'll give you 30 days for any narcotics testing that may occur. It'll be 30 days before the first narcotics test happens. You were out on bond in 2020 CF 11040AO. In that case, the court's going to revoke that bond. We're going to set a new bond amount of $2,500 with the same conditions: no drugs or alcohol. You'll be subject to random drug and alcohol testing in that case. You're also out on bond in 2021 CF 688AO. In that case, going to revoke that bond. We'll set a bond in the amount of $2,500. Condition your bond that you are not possessing any drugs or alcohol without valid prescription. You'll be subject to random drug and alcohol testing at your expense in that case as well. I'll give you 30 days before the first narcotics test happens. In those other cases, I want to appoint a public defender to represent you in all your cases. Have a great day, sir. All right, sir, can you tell me your name?
Luis Alberto Lavoy Carrera.
Mr. LaBoy, you're here in 2018 CF 14463AO on a failure to appear warrant. The judge signed your warrant, set your bond at $0. Your bonds will remain at $0. I'm going to appoint the public defender to represent you in this case. Have a great day, sir.
That's it, sir?
Yes, sir. Have a good day.
Have a good day.
You too. All right. Can you tell me your name, sir?
Jason Lott.
Mr. Lott, you are here in a few matters. The first one is 2020 CF 1513AO for a failure to appear. The judge signed your warrant, set your bond amount of $5,000. You're also here in 2020 CF 1524CO. In that case, for a failure to appear warrant, the judge in that case set your bond amount of $0. You're also here in 2020 CF 1672AO for a failure to appear warrant. The judge in that case set your bond at $0. I want to appoint a public defender to represent you in your cases, get you on to your division judge in your next court dates. Have a great day, sir. Can you tell me your name, sir?
Rodrigue McMahon.
Mr. McMath, you're here in 2021 CF 3371AO. The court did find, you were here arrested on two charges. The first one is trafficking in a controlled substance of 4 grams or more, and as well as possession of a controlled substance. The court reviewed the charging affidavit, did find probable cause for your arrest. I want to say your bond in count 1, amount of $1,000.
Your Honor?
Count 2, yes, ma'am.
I did have a PC challenge for the trafficking in a controlled substance of 4 grams or more. Upon review of the statute 893135, it states that it was oxy. Oh, here it is, sorry.
Oxycodone.
It was oxycodone. And the statute says that it must be 7 grams or more in order to be considered trafficking.
They changed the law from the last time
And
I
I'm
looked at
not-
it for the opiate?
Your Honor, I pulled the statute, the one that he was charged under, the 893-135 sub 1C61. That statute is for a different drug class. It is not for oxycodone.
Okay.
When I did look up oxycodone, it does say 7 grams or more will be the first degree felony, and then the amounts increase. So I do believe Ms. George is correct that to traffic an oxycodone, it needs to be at least 7 grams. The statute that the officer wrote, I believe it was for different drugs, including like salts and heroines, not oxycodone.
All right, so they increased the pill threshold, I'm guessing, to 7 grams?
I believe so, yes, Your Honor.
All right, sir. When did that take effect? This is just my edification.
I mean, I looked at the 2020 statute, and I also looked at the 2018, and the 2018 even has it as 7. You want me to show you what I'm looking at?
I'm just thinking about it. Last time I was involved in a oxycodone case, probably before that, people had moved on to hydros more than oxy. Perks. All right, sir. So I guess a lesser included offense would be possession then.
Yes, Your Honor.
All right, so I think you're already charged with that in count 2, so I want RR you as to count 1. Count 2, I'm going to set your bond amount of $1,000. Condition your bond is having not possessing drugs or alcohol without a valid prescription. All right,
So what the bond would be, sir?
$1,000.
That's $100 to get out, right?
Hey, you should be able to get out, just stay out of trouble.
Yes, sir.
All right, sir, tell me your name.
Keith Meisenberg.
Mr. Meisenberg, you're here in two matters. The first one is 2021 MO 358AO on charge of open container of alcoholic beverage, the violation of Orlando Sydney ordinance. And you're also here in 2021 CF 3358AO for possession of a synthetic drug or synthetic cannabis. The court did find probable cause in both cases for your arrest. I believe the offer from the city is a withhold and court cost if you want to resolve the open container case today.
All right, so I'll owe you money.
You're gonna have a year to pay that money, but not today. You're not gonna pay it today, unless you want to.
It'll work.
You want to take the offer as to your open
I'm
container
working
case?
so I can pay, yeah.
All right, do you want to raise your right hand to be sworn in?
Swearing? Yes, sir.
Yep. Do you solemnly swear or affirm the testimony you're gonna give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, sir, you're here in 2021 MO 358AO on charge of open container. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
How much fine?
The maximum penalties are 60 days in the county jail and a $500 fine. Do you understand that?
I do.
Do you want to enter a plea of guilty or no contest to resolve that case?
I'd like to resolve it. I'd like to see about getting ROR so I go back to work.
Well, let's talk about the resolving this case. So do you want to enter a plea of guilty or no contest?
No contest.
You understand by entering a plea of no contest, you give up certain rights in that case.
Well, I haven't heard any pleas or any offerings. So.
Well, the offer is a withhold adjudication and guilt credit for the 2 days that you spent in Orange County Jail. There's court costs in the case amount of $223. That's the
I agree
offer.
with that.
So do you understand by accepting that offer that you're going to give up certain rights?
Like what?
You're going to give the right to have a trial where the city's going to prove your guilt beyond a reasonable doubt. Do you understand that?
Yes, sir.
You understand you're getting the right to have an attorney appointed to represent you in there in that trial.
I understand.
At that trial, your attorney can challenge the state's evidence, they can question, or the city's evidence, they can talk to your witnesses and call witnesses on your behalf. Do you understand that?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, not at all.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand about entering this plea if you're not a United States citizen? If you're not a United States citizen, it could subject you to deportation.
What's that mean?
If you're not a United States citizen, entering a plea in the United States, in the state of Florida, it subject you to deportation by the United States government.
Okay, I'm a legal citizen, so.
All right, sir, I did have an opportunity to review the charging affidavit in your case. I did find a factual basis for the entering of your plea. I accept your plea of no contest, find that your plea is freely and voluntarily entered. I'll withhold adjudication of guilt. I give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. Court costs, in this case, of $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment sentence in writing.
Thank you, sir.
All right. As to your cannabis charge, or synthetic cannabis charge, they're going to set your bond in that case amount of $250. Condition your bond is you not possess any drugs, alcohol without a valid prescription. You understand?
Yes, sir.
All right. Have a great day, sir.
Is there any way I can get ROR?
Not based on your record and the failure to appear that you have in your history. The little statute doesn't allow for me to. It shouldn't. What tells me I shouldn't ROR you.
All right, yeah, I believe it was a reason for last time, like I wasn't aware, but.
That's something you can do at a bond hearing. It's on point the public defender to represent you. If that's become an issue, you can't get out. You get you in front of the division judge and maybe you can clear that up. But I don't have time to research that right now.
I understand. So $250 and I get to go home?
Yes, sir.
All right, thank you, man. God bless you.
Yes, sir. All right, all right, Kevin Miller bonded. Yeah. No, okay. Thomas. A lot of Millers. All right. And then Snell.
Yes.
All right. Can you tell me your name, sir? Mr. Snell, you're here in 2021 CF 3331AO on charge of possession of cocaine. I did review the charging affidavit in this case. I did find probable cause for your arrest. PTR, I don't see anything violent in his history to keep him out of the, keep him from not qualifying, right? Do you see anything in his history to keep him from qualifying? All right, Mr. Snell, I'm going to release you on pretrial release in this case. Condition of your pretrial release, you not possess any drugs or alcohol without a valid prescription. You be subject to random drug and alcohol testing at your expense. The first test will happen 30 days from today's date. All right, I'm going to appoint the public defender to represent you. Have a great day, sir.
Your Honor, would the battery and the resisting with violence preclude him? They're both convictions. He has resisting with and a battery.
I don't think so, yeah.
Okay, I just wanted to make
Yeah.
sure we weren't sending him if it wasn't gonna go.
All right, sir, tell me your name.
Yo, Janelle Bryant.
Mr. Bryant, you're here in 2018 CF 15864AO for a violation of probation. The judge signed your warrant for your violation of probation, set your bond at $0. Your bond will remain at $0. I'm going to appoint the public defender to represent you in this case. Have a great day, sir. Good afternoon, sir. Can you tell me your name?
Jason Edward Myers.
Mr. Meyer, you're here, it was Myers, I'm sorry, you're here in 1997 CF 14414AO for violation of probation. The judge signing your warrant from, in that case, set your bond at $0. Your bond will remain at $0. Say, I couldn't tell, but I'm gonna warn you anyways, you may be considered to be a violent offender of special concern based on, I don't know when your conviction happened, so I didn't have time to research that. But if that is true and you are a violent felony offender of special concern, you're not going to be entitled to release on bond in this case without before your completion of your violation of probation hearing. All right?
I got a question, Your Honor. Who was the judge that signed the warrant?
I want to appoint the public defender to represent you in this case. Let's see. It says Judge Calderon did. So I think you're in Judge Calderon's division. So you're going to have a good chance to talk to him about the case. All right, have a great day, sir.
Good morning, sir.
Good afternoon, sir. Can you tell me your name? Sir, you're here in 2017 CF 503AO on a charge of violation of probation. The judge signing your warrant in this case set your bond at $0. I'm going to appoint a public defender to represent you in this case. Sir, you are a violent felony offender of special concern, and you won't be entitled to release on your case until your violation of probation is completed.
So I'm a violent offender and what?
You are a violent felony offender of special concern.
Okay.
You're not entitled to release on your case until your violation of probation is completed. So you can't bond out until your violation of probation is over.
Okay, I go see my judge, right?
Yep. Yep, you go see him probably, you probably go see Judge Lattimore first at arraignment, and then we'll get on to your judge. All right. Is that point the public defender represent him?
Yes.
Okay. All right, tell me your name, sir.
Joel Soto.
Mr. Soto, you're here on a violation of probation in 2019 CF 14544AO for charge of violation of probation. The judge signed your warrant in your case, set your bond at $0. Your bonds will remain at $0. I'm going to appoint a public defender to represent you in this case. Have a great day, sir.
I have a lawyer.
You have a lawyer?
Yes.
Okay, that's fine. You already paid them? They're on the case?
The thing is, they said that I violated my probation for being around the kid, but I could be around the kid. Court order said that I could be around the kid.
Sir.
And my lawyer said,
Don't talk to me. Look, listen. Everything you tell me is on the record. So what you're telling me, you think may help you, may not be helping you. All right? Because there's a state attorney sitting over here listening to you, and there's somebody recording this. Everything that we're saying is writing it down and audio recording it. So don't talk about the facts of your case of why or how you violate your probation. If there's a dispute, I'm appointing a public defender to represent you, or you can get your own lawyer. But I don't want you sitting here in jail thinking that you have a lawyer and you don't have a lawyer.
Your Honor, I believe he has RCC
We have regional conflict for this case, for the violation of probation, or for the old case?
for the old case.
Yeah, so they don't carry over on the violation of probation because they don't have the same conflict they may have had at the public defender's office.
yeah, my
I
lawyer
want to appoint the
said-
public defender office to represent you. If they still have that conflict that precluded them from representing you in the old case, they can represent you, they can still get you over to RCC so you can have the attorney represent you. I don't want you sitting in jail without representation, wondering what's gonna happen. So we
Yeah,
get you over to
because
Judge Lattimore in
my
a few weeks.
my lawyer name is Leon Cheeks.
Yeah, Mr. Cheeks works for the Regional Conflicts Office. So,
He told me, when I was on the phone with him, he told me to let y'all know that he's my lawyer.
all right, I gotta go through the process. So Mr. Cheeks may end up being your lawyer again, but if he was the lawyer on the original case, his representation of you ended 60 days after that case was resolved.
But it haven't been 60 days because I got probation on March 1st, and they said that I violated probation. I didn't even violate because I got court orders saying that I could be around the kid because the kid is living in my mom's
Stop
house.
talking about your facts. Listen,
You know, like I don't
I understand what you're saying.
I'm literally innocent in here.
No, looking for, yeah, there you go. When did your probation start? Yeah, so he may still represent you. So I'll keep Mr. Cheeks on the case because technically his representation isn't over for you. But we'll get you on, Mr. Cheeks. You'll see Judge Lattimore the next day or two.
When is my next court date?
Probably VOP arraignment, so having Judge Lattimore probably next week or in a couple days here.
Okay.
So like 2 courtrooms down in BRC 3.
You're gonna let me know right here?
They'll get you paperwork, yeah. I don't know when I can tell you right now. All right, tell me your name, sir.
Hearing White.
Mr. White, you're here in 2018 CF 9081AO for violation of probation. The judge signed your warrant in that case, set your bond at $0. I want to appoint the public defender to represent you in this case.
I got a lawyer too.
You got a lawyer? Who's your lawyer?
Leslie Sweets.
All right, Ms. Sweet. Is Ms. Sweet following those appearance? Did you already pay Ms. Sweet?
Yeah, I already signed my plea and everything. I've been locked up in Tampa. So,
All right.
yeah.
All right, so I won't appoint the public defender to represent you. If we get you on, Ms. Sweet, we get arranged with Judge Lattimore possibly to resolve your case.
I already got a court date and everything. I just got sent here.
All right, so I had to tell you about, all right, have a great day, sir. All right, tell me your name, sir.
Daniel Winkler.
Mr. Winker, you're here in a few matters this afternoon. First one is 2019 CF 5598AO. In that case, there's a violation of probation allegation, and the judge signed your warrant, set your bond at $0. You're also here in 2019 CF 8054AO for a violation of probation, and the judge in that case set your bond at $0. You're also here in 2019 CF 11938AO for failure to appear. And in that case, the judge set your bond at $0. You're also here in 2021 CF 3362AO for possession of fentanyl. And in that case, the judge set I found probable cause for your arrest. I want to stay your bond in the amount of $2,000. Conditionally, your bond not allowed to possess any drugs, alcohol without a valid prescription. I want to appoint the public defender to represent you in all your cases so we can get you on to your division judges to resolve your cases. Have a great day, sir. All right, tell me your name, sir.
Christopher Cruz.
Mr. Cruz, you're here for an also out of county warrant for 2020 CT 3043 out of Osceola County. The judge signing your failure to appear, set your bond at $0. Your bond remain at $0. We'll get you down to Osceola the next day or two to resolve that case. Have a great day, sir. And Sanchez was my last person. All right, Sanchez bonded. That's not good, but all right. All right, does anybody have anything for the better of the order?
No, Your Honor.
No, Your Honor.
All right, everybody, let's take us into recess. Well, we're adjourned today.